Donna Adelson, a 75-year-old grandmother, was convicted by a jury in Leon County, Florida in September of first-degree murder. For those that are not familiar with the backstory, Donna Adelson had a daughter. Her daughter's name was Wendy. Wendy was married to a law professor named Dan Markell. Mr. Markell taught at Florida State University in Tallahassee. Wendy and Dan were married and had 2 children together. Unfortunately, the marriage did not work out and they got divorced. Like many divorces, it involved a bitter custody dispute. Wendy wanted the kids to relocate with her down to South Florida, to the Miami-Fort Lauderdale area where she was from, and Mr. Markell wanted to stay up in Tallahassee to stay where he taught at Florida State University. So, Donna Adelson had a very bright idea, and she, together with her son Charlie, who was Wendy's brother, decided to solve the problem by hiring a hitman to murder their son-in-law, Dan Markell. In July 2014, Mr. Markell was driving up to his driveway in his house in suburban Tallahassee. 2 men pulled up in a car. One of them gets out of the car, walks up to Mr. Markell's car, shoots him, kills him, and then the 2 men drive off. It took prosecutors and law enforcement a number of years to unravel the case. It turned into a large conspiracy that resulted in a conviction for the triggerman, the driver of the vehicle. It turned out the son, Charlie Adelson, had conspired with his mother, Donna, to hire these hitmen to conduct the shooting and the murder. And they too were both convicted. Now, the interesting part, Donna was just convicted. And one of the aspects that's going into her sentencing now is whether she's going to have to pay restitution. Restitution is essentially the costs that the government incurred in prosecuting her. And now that she was convicted, she was found guilty, she has to pay the government back. One of the many podcasts that was covering this, one of the guests raised the question, well, if they're going to go after Donna Adelson's assets in order to cover the restitution judgment, what happens if she transferred those assets out of her name? And they speculated that that might mean that there's no ability for the state then to recover any assets to satisfy that restitution. So I was curious because in bankruptcy, there's a very foundational aspect of bankruptcy law, and that is you cannot transfer assets out of your name for the purpose of defrauding your creditors, right? So if I owe $1 million, let's just say to the IRS in back taxes, right? Or make it simpler, I owe my credit cards $1 million, and I have a house, a big mansion in Miami with no mortgage on it worth $1 million. And I say, well, I want to be able to keep my mansion and not have to pay my credit cards. But if it's in my name, they're going to see it's in my name and they're going to come take it. So I have a bright idea. Okay, I'll sign the deed to my mansion over to my wife or my kids, or put it in a trust for the benefit of my kids. And some people might think that's called aggressive asset protection or estate planning. In some circumstances, that might be true. But here's the catch. If you already owe the money and you're doing it for the purpose of trying to get the assets out of the reach of creditors because creditors can no longer take it because it's not in your name, that is considered fraud. And under bankruptcy law, you can be sued by a creditor or by a bankruptcy trustee. A bankruptcy trustee is somebody who's appointed by the courts to administer these Chapter 11 cases, act kind of as the watchdog, and they have a lot of ability. They have a fiduciary powers, and they can play a critical role in filing lawsuits to uncover assets for the creditors. So this bankruptcy trustee has the ability to file a lawsuit against the recipient of these assets and say this whole transfer should be undone, pretend as if it never happened, put it back in the name of the original person. Now that it's back in the name of the original person, it's now able to be brought into this big pool of assets called your bankruptcy estate, which can then be used to distribute to your creditors. Now, keep in mind, bankruptcy is federal law. So a lot of states have also enacted their own version of this. Now, Donna Adelson was convicted of first-degree murder. It's a state crime. She was not convicted of a federal crime, and she's not under any federal bankruptcy. So the regular bankruptcy provisions would not apply because she was not in any kind of bankruptcy proceeding. But I was curious, is there a similar law in Florida that mirrors this concept of bankruptcy? And if so, can that be used to then undo any transfers she may have done and bring assets back into her name, and therefore the state can now take that to satisfy that restitution? So there actually is. There is a statute in Florida, the Florida Uniform Fraudulent Transfers Act. And it acts very similarly to the bankruptcy provisions. And I'm going to break it down. It says here, and it really mirrors the bankruptcy concept. A transfer made or an obligation incurred by a debtor. So who is a debtor? A debtor is somebody that owes money. So in this case, Donna Adelson, who is also a convicted killer, is the debtor to the state because she now owes the state of Florida restitution. And now a transfer made. So again, a transfer would be as if the Adelsons were said to, or the reports that the Adelsons own a lot of real estate. If that's true, and they took that real estate and they signed a deed transferring the real estate to a third party, maybe it was to a trust, maybe it was to her husband, Harvey Adelson, who has yet to be charged with any crime, or maybe it was to their kids, which is very, very sad because there's two grandchildren, the two children of Mr. Markel and Wendy Adelson, and if they transferred it to the name of those kids or as kind of a trust for those kids, it would be very sad if now the state is taking away this money that the kids should have had. So it's a horrible tragedy, aside from the fact these kids lost their father, they lost their grandmother who's now in jail, and their mother might very well end up going to jail too, and they don't get to see their grandparents on their father's side very frequently. And now any assets or any money that could have potentially been left to them as an inheritance, they're also going to lose out on as a result of the crimes committed by their mother's family. So now back to the statute. So if these kids or whoever this third party was received it was transferred to them, that transfer can be considered fraudulent as to a creditor. So who's the creditor? In this case, it would be the state of Florida, whose claim arose before the transfer was made. So this is an interesting concept. When does a claim said to have arisen? That can be very factual based. Simply speaking, at the most basic level, the state would argue that the claim, the right to receive restitution, occurred when the crime was committed. Now, the defense might argue otherwise, it may take a different interpretation, but if the state were to argue that the claim arose when the crime was committed, and therefore the transfer took place after the crime was committed, well, that means the right to receive the money came before Donna Adelson transferred this asset or this real estate. Then, if the debtor, meaning Donna Adelson, made the transfer and she received nothing in return without receiving a reasonably equivalent value in exchange for the transfer. Again, plain English means, did she get anything back? when she signed the deed over, was there money paid? Did she receive any money for it? Or was it just a gift? If it's just a gift and she received nothing in return for it, then that could be considered fraudulent. Now, the statute goes on to list a whole bunch of other technical aspects, but it mirrors the same concept. So what happens now? What is a creditor's right? In an action for relief against a transfer or obligation, like we said above, what can they do? A creditor may avoid the transfer to the extent necessary to satisfy the creditor's claim. Now, avoid, it's fancy language. It just means undo. They file a lawsuit to say that transfer should never have happened. So, to wrap it up, if Donna Adelson, it can be proven that she made the transfer and she made the transfer after she became obligated to pay the restitution and she did not receive anything in exchange for it, it could be considered fraudulent and the state can sue to undo all that and bring all that back. So the mere fact that she transferred these assets out of her name does not help her. It's only going to make things worse for her and her family. Hard to imagine how things can get worse. She was just sentenced to life in prison. She's never going to see the light of day. But if she cares at all for her family members who are still out of prison, this will create more headaches for them. And if she cares for them, this is not going to be a good or pleasant or easy thing for them to go through. There's going to be more court battles, more drama, and the real victim here, again, is the Markel family and the two little children who lost their father. That's it for now. If you like this video, please remember to like, comment, and subscribe, and we'll see everybody next time.